Okay, good morning. How many of you have had an appeal before the West Virginia Supreme Court? Oh, good. How many have not? So, this will allow me to take track 2 that I wanted to do on this, which is basically sort of go rather quickly over my presentation and get to what I think are the more important things about trying to do a GAL appeal currently with our Supreme Court. My name is Bob Wilkinson. Until this past summer, I was Chief Public Defender for many years in Cabell and Wayne County. I'm out now, just running my own thing, and this is basically what I do. Is GAL work and a handful of other things on the side. Let's see what it's going to do. Okay. Let's start with appeals. We're going to do the 3 basic things that we have available: appeals, writs of mandamus, and writs of prohibition. For those of you who are not aware, and it's hard to believe that any of us are, but you've got to do this. If you don't, the Supreme Court will squash you. About as hard as they squash any attorney in writing. If you doubt me, take a look at this. When it came out, I was actually surprised at how hard it was. Let's speak a little context here. Did you take a look at the scope of that report? Basically, the GAL report. Basically, what's happening is you're there to fill in the parts of the record that aren't being filled in. And in a lot of these cases, there's big holes. So that's really the function of the GAL report. When you get to the Supreme Court, the prosecutor's not there. He's represented by the AG's office. The AG is handling hundreds of these things. And you're the only person who has the experience of the case that's on the side of a court order normally that's being challenged by the respondents to say, this is why the judge did what he or she did. So that's the reason the Supreme Court is putting so much weight on the presence of the GAL. And let's face it, we spend an awful lot of our time trying to watch out for the interests of our clients, and that means that we're having all sorts of interactions with providers, with the DHHR, with other counsel. We probably normally have a wider perspective on this case than anybody else who can show up in front of the court. And if they have an oral argument, you've got to be there. There is the ability in the West Virginia Code to file an interlocutory appeal from an adjudicatory hearing. So what you technically could do is, you could do an appeal from an adjudication. That normally isn't there for you. But normally what will happen with us is that we may have a situation where a GAL is appealing something that is in between. And we're going to get into that later when we do particularly prohibitions, but also mandamus. So if you end up with a situation where your judge is continuing to give chance after chance after chance, and you believe that the chances are well beyond what they are allowed to do under the law, then you have the ability to file your appeal before the final disposition, or seek to force a disposition through the extraordinary writs that we'll talk about at the end of this. The biggest weapon you have right now is in the GAL report and or the use of proposed findings of fact and conclusions of law under Rule 30. Now, Rule 30, how many of y'all are aware of what Rule 30 is? Okay. Let me tell you what Rule 30 is. If you take a look at the way these cases are supposed to flow, there are two huge events procedurally in them. The first is the adjudicatory hearing, which decides whether or not you want to proceed. The second is the disposition hearing. And there are all sorts of things that are supposed to be there for the disposition hearing. There's supposed to be a filed improvement period, which was done earlier in the case if you have an improvement period. Whether or not you have a filed improvement period or you don't have it, you're supposed to have a disposition case plan, which is reviewed by the MDT team and the DHHR publishes to the court. Now, the Supreme Court has been making more and more noises about these disposition plans and the lack of the disposition plans. Basically, what's happening is court summaries are being thrown in, and they will say, well, here's where the children are, and here's our plan, da-da-da-da-da-da. But it really doesn't give much input from hardly anybody else, does it? And did the MDT team decide that, which is required by Rule 30? If you have gaps in this area in preparations for disposition hearings, take a look at the high 20s and low 30s in your procedural rules. You'll be shocked at how much is supposed to be on the record in front of the judge and when the judge makes his or her determination on a disposition. GALs have the opportunity through the reports and through the proposed findings of facts and conclusions of law to have a huge impact on a disposition hearing. Let's face it, primarily because nobody else is doing it. Do you ever see these? You ever see these from respondent counsel? How many see them from any respondent counsel? There's one, but probably you do it. Sometimes. Let me tell you something. If you have a case that you think there is a good chance of an appeal coming out of it, you need to take a look at doing one of two things. The best thing you can do is to do your GAL report and put in these types of procedural things and annotations towards the end. The second thing you can do is you can just do proposed findings of fact and conclusions of law aimed at the judge to say, here are the facts and here's where we're going. How do I do this? The smartest way to do this is to do two things. All disposition hearings are built around a single section of the code. 49.4, 604. And subsection B is the vast bulk of it. If you go through, as I'm going to advise you to do here in a while, if you go through the last 6 months or so of Supreme Court cases and you take a look at what the court is actually saying now and the analysis it's using, you'll find that over, or virtually all of them, quote 604 extensively. And there's a couple of really interesting portions of 604 that I want to put on your radar. Not only for disposition hearings, but also for adjudicatory hearings, for how you're handling MDTs, and ultimately, how you're going to set up a case for an appeal. Appeals are a little bit like mandamus. Once you've done a couple of them, you have a pretty good idea of where you can slip up. And so you start to develop habits to avoid the problems that you've seen in mandamus cases that you've handled, or perhaps in appeal cases that you've handled. Let me tell you the biggest thing the Supreme Court is doing right now. (49) 4 604. Where do I have that? B in parentheses, little 6 in parentheses. In fact, in the last several months, when they are upholding terminations, they're going to this section again and again and again. This is the code's examples of what no reasonable likelihood that the conditions of neglect or abuse can be substantially corrected in the near future are. Now, the code says it isn't limited to this, but if you take a look at those conditions, you'll find that that's the vast majority of your cases. Oh, I'm sorry. Yes, it is. I'm looking for the number here.
7C.
Yes, 7. It's is it 7C? Under this section, no reasonable likelihood of conditions neglect. No, that's aggravating. Well, it does have aggravating. Yes, it's 7C. You'll have to excuse me. I've driven from Cincinnati this morning, so I'm a little covered. But when you take a look at that, number 1 is the abusing parent or parents have habitually abused or addicted to alcohol or other controlled substances, and that they're serious, that led to serious impairment. That's like 50% of the cases right now that are being upheld by the West Virginia Supreme Court are citing that subsection. Do you think your judge is interested in that? Do you think your judge is interested in how he or she can enter an order that the West Virginia Supreme Court will take a look at and say, well, yes, that's exactly the type of thing that we want you to look at. Take a look at this subsection. And it is 7. Yeah, 7C. There's like 6 different conditions. And then there's alternative dispositions are listed right after that. The other thing that they do is that they want the judge on the record to walk through, once they just walk through the things that are establishing those conditions for no reasonable likelihood. When you take a look at the Supreme Court, they're writing their opinions and they start saying, we don't know about this record, and they'll start taking a look back to say, well, first of all, we don't have a disposition plan, or we don't have this, or we don't have that. That's what they're looking for. They're looking for those conditions. What evidence is there on the record that those conditions have been met? So really, that's your beginning roadmap. When you're taking a look at adjudication, when you're taking a look at disposition and all your recommendations, take a look at those definitions and say, does this case meet it? If it doesn't, why not? Here are the reasons. If it does, here are the reasons. You've just written your brief to the West Virginia Supreme Court. That's what they're dealing with right now. They also deal quite a bit with whether or not alternative dispositions need to be taken. That's listed a little bit earlier. But the big thing, and also the factors under B6, there are a few other things that they want to have considered at the time that they make the determination on no reasonable likelihood. You'll find those in B6. And then B7, as he said, has all the different definitions. doing those proposed findings of fact and conclusions of law, or the GAL report, if you're taking a look at what your judge is most interested in, that's going to be the question. What should I do? Is there enough evidence? And what is the legal citation for? Well, you've just got the two major legal citations for it. You have to file your notice of appeal within 30 days of judgment. That's the Rules of Procedure 11. I actually had this come up a few weeks ago, and the question was raised, but it was filed back in the circuit court. And I had to, in putting the response together, I had to figure out, well, does this go in the circuit court? Because, you know, as a matter of just basic function, in a lot of cases, the circuit court does sort of grant that because of what the clerk does and things like that. No, it appears from the rules that if you want to change that deadline or do anything on this, you have to file with the West Virginia Supreme Court. This is a really major thing to remember because you will hear this question time and time again. I was in Cincinnati yesterday and dealing with a prospective adoption there. Everybody was asking, well, you've got an appeal going. What does that mean? And I said, we keep going. There may be a point where we think about postponing the final hearing, but all other preparations keep going. It doesn't stop the process at all. There is the ability to try to stop it, but that's a separate hearing in front of the judge. And we'll go over that here in just a little bit. Transcripts need to be submitted when there are disputed evidentiary or testimonial issues. Some of you may remember a few years ago, the West Virginia Supreme Court had this highly expedited timetable, and in a way, in trying to deal with it, they said, we don't need transcripts. And we want a really truncated record. That's not there now. Basically, what they want you to do is to get together as counsel, decide what the record is going to be, and decide the transcripts of those major hearings that you're going to be citing back and forth for evidentiary purposes. That's normally going to be the disposition hearing. How many of you all have filed an appeal and cited the disposition hearing as your primary hearing? Okay. Several? Another really good reason to have your ducks in a row for the disposition hearing. Because when you take a look at the procedural rules and everything else, that's where the court's going to look. And if you set it up correctly, you may well be able to have the transcript most of the time coming out of the disposition hearing. Go over the proposed appendix with the other parties. So you're trying to work to stipulate on it. You do have the ability to file a motion to supplement the appendix under the rules of procedure. The best way to do that is to call to the clerk's office. They have a really outstanding staff in this area, and if you can develop a good rapport with them, and you keep in mind just one rule, I need to try to call them early. Don't call them in the last 24 to 48 hours of the last 1 or 2 working days. If you do that, then supplementing appendixes, deadlines, things like that, you know, and other explanations as to what's going on with the case can really help you out. Indigent persons are entitled to transcripts without cost. The forms that you fill out with the court reporters, they'll take care of that for you. Okay. These are going to look an awful lot like sort of a much smaller version of the GAL report. But these are the things that are on the notice of appeal. And, you know, it's not unusual for the Respondents' Council to want to call you and try to go over this. If they do, yeah, that's a really good idea. And get that together, because when you go to file your brief is going to have, you know, an expectation that you have this in the procedural history and the status of the children's section. As I said, it's mostly already in the report or in the presentations that you've given, so that hopefully they'll have that. The petitioner's brief and appendices are filed with the Supreme Court within 60 days of judgment. Okay, let me ask you something before we go to stays. What is the date of judgment? That's right. The day that the actual, usually disposition order, that you are appealing from is actually entered in the clerk's office. In some counties, that's pretty quick. In some counties, it's going to take a while. But that's the thing that drives everything. It drives your 30 days on your notice to appeal. It drives your 60 days on the initial response. It's going to drive everything in the case. Stays. As we said earlier, the appeal doesn't automatically stay the proceedings in the abuse and neglect cases. You or the Respondents' Council, if you're seeking to stay what's going on, you have to file a motion with the circuit clerk, and then there's also a notice if it's affecting a Supreme Court appeal where you file the motion with the Supreme Court. Those are the two rules that are in play there. Any questions so far? Any questions? Yes?
Do you refer to the parents by initials, by their first name and last initial?
Well, I use two initials. And I know it gets a little confusing when you read the cases. They're generally doing two initials now, aren't they?
Yes.
Yeah. Now, sometimes, though, the two initials get confusing because it isn't unusual for you to have a child with the same initials as a respondent parent or something like that. And I had one recently that was like that. And so what I did was I went back and where I had sort of confusing initials going back and forth, I put respondent parent, these two initials, as opposed to, you know, just using the initials over and over and trying to get them to figure out what to do with it. Yes?
What's our role if the respondent parent appeals to the U.S. Supreme Court, the West Virginia Supreme Court decision? Do we follow that there? I made a few phone calls to the U.S. Supreme Court, haven't got any direction, but...
Well, who appointed you?
No one.
No. Who appointed you guardian ad litem at the beginning? The circuit court?
Correct.
Okay. And this is an abuse and neglect proceeding, right?
Correct.
I would call Public Defender Services and tell them that you view it as being an ancillary proceeding. Because it would be an ancillary proceeding if you went to, under a criminal case. I think it's ancillary under the PDS code. But it would be a good idea to run that by them and tell them this is coming up. They'll probably want to plug you in with all sorts of people to help you out on any appeal going to the West Virginia, on the U.S. Supreme Court. But I would say it's probably ancillary.
Not to mention the pay rate probably will go up with it being a U.S.
Oh no!
Your public defense.
If you're paid by PDS,
Please.
you're paid $45.65 until, well, who knows at this legislature.
Well, if he can get it through the public defender's office to work with the U.S. attorneys a public defender's rates, he might get an increase in his pay, doesn't
Well, but they can't pay the federal rates. And I'm sure the U.S. Public Defender's Office won't appoint you for that. Yes.
I just wanted to mention on initials, I had one like that where the parent and the child have the same initials except for the middle initial.
Yeah.
So when I sent in the notice of appeal, I included middle initials. When it came back from the Supreme Court, they put the first and last initial and put 1 for the parent and 2 for the child. And they referred to it as like DP1, DP2.
Yeah, it does get a little confusing.
That was the Supreme Court.
You know, one thing you might do is if you have something that is that close, you know, at the very beginning, when you're talking about the history of the case, talk about, I'm going to be using these initials.
Oh, I
because
did
of this.
identify
I'm sure you
it,
did.
but the Supreme Court changed it anyway.
Yeah.
They said, this is how we're referring to it. It was 1 and 2.
Yeah, and it works. I can't tell you that I know that that's happening all the time. But in your own pleadings, that might be a good thing to use, and maybe something for us to use in the future. My best advice would be just explain up front what you're doing with the initials, for sure, so they'll know. Yes.
I recently had a legal case where the 3 children had the same initials. What the court did was they designated AP1, AP2, and AP3.
Yeah.
And on a separate topic, talking about the information needs to be updated by the guardian ad litem of each report.
Yeah.
Now the Supreme Court is sending out separate the request where they're having everyone involved in the appeal submitted up to the while it's really
I haven't seen one of those yet.
They've been sending those out prior to oral arguments.
Okay, so ones that actually go into oral arguments, they're looking for that from all the parties, not just the GAL.
Yes.
Okay. Well, that's a good update. So if you get one of those notices saying, we want an update from all parties, it looks like you're moving beyond the memo decisions, which is the norm. Yes.
Back to this appendix. What I find is that guardian ad litem, when I have to do a response brief, I'll find the respondent's parents file the appendix with the Supreme Court, and I'll give the Attorney General one, but they never provide me with the appendix. All I get is their brief, and they say, well, it's not in the rule that I have to do this. How do you get the damn appendix when
It's in the rule.
well,
It's in the rule. I'll have to say that the attorneys in my area are very diligent about getting things like that to the guardian ad litems and to all the different parties that are around.
You know, well, there's 4 of them. They said, well, that's 1,000 pages. I'm not copying that. So you don't.
Yes.
If you email Bond, he'll send it to you electronically.
What's that now?
If you email Bond to the clerk's office, Bond sends you the appendix electronically,
Okay.
if that happens.
Okay. So if that does happen, you can email Ms. Summers. Is that correct?
Ms. Sagan, Bond Summers.
Vaughn Summers.
Bond.
Vaughn Summers. I'm sorry.
Sorry.
Email Vaughn Summers at the clerk's office, and they can send that. They can send you as GAL the electronic appendix that they're keeping. I've never had that problem, but apparently it does pop up from time to time. So Mr. Summers can send that to you from the clerk's office. Yes.
Some of the attorneys have been sending the appendix on discs to avoid paper.
Well, that could work, I guess, as long as the Supreme Court is willing to take it, or it's okay with you all, and you can read it. And his comment was that some, for those of you on the other side of the room, this has been a discussion on what do you do if you don't get an appendix? And first of all, you're required to get the appendix. And then secondly, if all else fails, you can contact Mr. Summers at the State Supreme Court Clerk's office, and they will send you an electronic copy. There have also been some places where you will receive it on disk from the counsel who are filing the appeal, and that makes it a whole lot easier than just going out and having to make all the copies.
So you can get a copy from the Supreme Court when they refuse to give you one?
Yeah.
Just
Contact the clerk's office and say, they're not giving me one, can you send it to them? And it's basically their electronic version of it. So you'll have to have the ability to, download that and read it and all the rest of it.
As respondents counsel, when I'm consulting with the other parties to see what needs to be included in the appendix, I usually reach out and ask them, would you rather have a paper copy, electronic, or both? Because some attorneys would rather read it electronically, others paper, and then I'm choose.
Okay, so there is a suggestion that in some places, the appendix discussions include how do you want it. Do you want it electronic, do you want it in paper, and then they'll go ahead and send it based on preference. Okay. There's a thing, I'm running out of time, I want to tell you, there's writs of mandamus and writs of prohibition. In a mandamus, you have to have a clear right to the relief that is sought. You'll see that once in a great while, it's been used to require DHHR to pay for therapy at the Medicaid rate, and it's also been suggested as a recourse for former foster parents in the case law of our Supreme Court. If you're like me, you have all sorts of problems going on with the service levels that are going to your clients. I spend a huge amount of my time trying to keep that going. And I, for one, am terrified of the managed care bill. They did this on a smaller level with my specialized medically fragile clients 3 years ago, and it's been a complete debacle. And now they're seeking to do it with everybody else in foster care. So, if that full change doesn't take place, and apparently they told the legislature the other day, it doesn't matter, we're just going to do it. So they told the legislature for 2 years, we need your approval. Then they said last week, no, it's a matter of policy between us and the feds, we're just going to do it. So you're going to end up with threatening them with mandamus and a bunch of other things probably soon. So if you end up in those situations, take a look at the mandamus section. Writ of prohibition, that's seeking to prohibit something that the court has done. There is case law where the courts have extended improvement periods beyond the limits that are set by the statute, or where you believe that reunification with the parents or another placement like that is not in the child's best interest. Prohibition would be one of your remedies. And prohibition has a built-in stay, usually, because when they grant that writ, it stays. So if you're looking for something that can move quickly, particularly after perhaps some reunification or something like that, prohibition is the thing you want to take a look at. It's in the last few pages of the presentation here. As usual, I run over a little. Thank you very much, and it's really heartening to see all of you out. A lot of good work.